Imagine a company earning thousands of crores in profits, shareholders celebrating growth, directors discussing expansion, luxury offices rising, executive compensation increasing, but outside corporate walls, surrounding communities still struggle with poverty, pollution, education gaps, and healthcare crises. Now imagine a law powerful enough to transform corporate profitability into social responsibility and legally compel companies to spend on nation building itself. That transformative governance revolution arrived through Section 135 of the Companies Act 2013, India's landmark corporate social responsibility provision. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing one of the most globally discussed, socially significant, and governance driven provisions under the Companies Act 2013, Section 135, dealing with corporate social responsibility, commonly known as CSR. This provision fundamentally changed the philosophy of corporate governance in India. Historically, corporate law focused primarily on shareholders, profitability, and financial accountability. But Section 135 introduced a much larger governance vision. A company does not operate in isolation. It utilizes public infrastructure, human resources, natural resources, financial systems, social ecosystems. Therefore, large profitable enterprises must also contribute towards social development. This is the philosophical foundation behind CSR. To understand Section 135 properly, we must first understand why CSR became legally significant in India. Before the Companies Act 2013, many companies voluntarily engaged in philanthropy and community welfare activities. Industrial groups established schools, hospitals, and charitable institutions. However, these efforts were inconsistent and largely discretionary. The legislature believed that large companies benefiting from economic growth should systematically contribute towards social and environmental welfare. Thus, Section 135 introduced structured CSR obligations. This made India one of the first major jurisdictions globally to create a mandatory CSR spending framework through company law. Now let us understand the statutory framework carefully. Section 135 applies to every company having net worth, turnover, or net profit above prescribed thresholds during any financial year. Immediately, an important practical concept emerges. CSR applicability depends upon financial thresholds. This means not every company automatically falls within Section 135. Threshold analysis becomes the first compliance exercise. Now let us discuss the thresholds conceptually. Companies crossing prescribed net worth, turnover, or net profit criteria become subject to CSR obligations. This includes certain private companies, public companies, and even foreign companies having qualifying operations in India depending upon circumstances. Now let us discuss the legislative intent deeply. The objective is not merely charity. This is extremely important. CSR under Section 135 is a governance obligation connected with sustainable development, stakeholder responsibility, and ethical corporate citizenship. The law wants companies to contribute meaningfully towards societal welfare. Now let us discuss the CSR committee because this is one of the most operationally important aspects. Eligible companies are generally required to constitute a CSR committee of the board. The committee plays strategic governance role. It formulates CSR policy, recommends expenditure, monitors implementation, reviews projects. This transforms CSR from casual philanthropy into structured governance activity. Now let us discuss composition of CSR committee, board structure, independent director requirements, and company category influence committee composition rules. Listed companies and large public companies often face more structured governance expectations. Now let us discuss CSR policy. The CSR policy is not merely a ceremonial document. It defines the company's social responsibility framework. Areas of focus: implementation strategy, project monitoring systems, governance structure, reporting mechanisms, all become critically important. Now let us discuss the famous 2% rule. Eligible companies are generally required to spend at least 2% of average net profits of preceding financial years on CSR activities. This transforms CSR discussions across corporate India. Now think practically about the governance implications. For large corporations, CSR budgets may involve hundreds or thousands of crores. This creates major governance responsibility. Project selection, fund utilization, monitoring, transparency, impact assessment, all become legally significant. Now let us discuss Schedule 7 because this is one of the most important practical areas under Section 135. Schedule 7 specifies eligible CSR activities: education, healthcare, environmental sustainability, rural development, gender equality, disaster relief, skill development, national heritage protection. Various socially beneficial activities fall within this framework. Now let us discuss a hidden practical concept. Not every charitable expense automatically qualifies as CSR expenditure. This is extremely important. Activities must align with Schedule 7 principles and CSR rules. Improper classification creates compliance risk. Now let us discuss implementation mechanisms. Companies may implement CSR directly through registered trusts, registered societies. Section 8. Companies. Collaborative projects. Government-approved funds in specified cases. Operational structuring becomes critically important. Now let us discuss board meeting implications. CSR becomes recurring board governance agenda. Policy approval, project review, budget monitoring, unspent amount analysis, impact assessment, disclosure review. All these require board oversight. Now let us discuss unspent CSR amounts because this area creates enormous practical significance. If CSR obligations remain unspent in specified situations, transfer obligations may arise toward designated accounts or funds depending upon circumstances. This transforms CSR from a comply or explain culture into a more stringent compliance regime. Now let us discuss the concept of ongoing projects. Where CSR spending relates to ongoing approved projects, special treatment may apply regarding timelines and transfer mechanisms. This area is heavily tested and practically important. Now let us discuss practical governance chronology. Threshold applicability examined. CSR committee constituted. CSR policy drafted. Board approval obtained. Projects identified. Implementation agencies selected. Budget allocated. Monitoring systems established. Impact reviewed. Board's report disclosures prepared. This entire process requires sophisticated governance coordination. Now let us discuss disclosure requirements. CSR disclosures in board's report are extremely important. Stakeholders examine whether spending occurred genuinely and effectively. Listed companies especially face public scrutiny regarding CSR claims. Now let us connect section 135 with section 134. Board's report must include CSR related disclosures. Thus, section 134 and section 135 operate closely together. Weak CSR reporting may create governance concerns. Now let us discuss practical examples. Suppose a manufacturing company operating near rural communities undertakes healthcare and education initiatives. If projects align properly with Schedule 7 and governance norms, CSR compliance strengthens both social impact and corporate reputation. But suppose another company merely donates funds casually without proper documentation, monitoring, or eligibility analysis. Now governance risk emerges. This distinction is critically important. Now let us discuss a practical case study style illustration. Imagine a large listed company publicly claiming major CSR expenditure for environmental sustainability. Media praises the initiative. Investors appreciate ESG commitment. Later, regulators discover that funds were routed through questionable intermediaries without genuine project execution. Now the company faces governance scrutiny, reputational damage, and possible compliance consequences. This demonstrates why CSR governance must be authentic. Now let us discuss another practical issue. Many companies incorrectly assume employee welfare activities automatically qualify as CSR. This is a major misconception. Activities exclusively benefiting employees generally do not qualify as CSR under the rules. This becomes a frequent compliance mistake. Now let us discuss the role of company secretaries. Company secretaries play a central role in CSR governance, committee constitution, policy drafting, board procedures, disclosure compliance, documentation management, regulatory coordination, monitoring timelines. The role is highly significant. Now let us discuss the role of chartered accountants. Verification of CSR expenditure, accounting treatment, impact on financial reporting, and audit review become important. Improper classification may create audit concerns. Now let us discuss cost accountants. In manufacturing sectors, environmental and sustainability initiatives may intersect with operational cost governance and efficiency analysis. Now let us discuss advocates and litigation implications. Disputes involving misuse of CSR funds, governance failures, related party concerns, or false disclosures may involve legal scrutiny. Regulatory interpretation issues also arise frequently. Now let us discuss connection with ESG governance. Globally, environmental, social, and governance frameworks increasingly influence investment decisions. Section 135 indirectly strengthened India's ESG ecosystem long before ESG became mainstream corporate vocabulary. Now let us discuss SEBI relevance. Listed companies increasingly disclose sustainability and business responsibility information. CSR governance, therefore, interacts with broader ESG and investor disclosure expectations. Institutional investors monitor CSR quality closely. Now let us discuss FEMA and cross-border implications. Foreign-owned subsidiaries operating in India may also encounter CSR obligations depending upon thresholds and structure. Global parent companies often examine Indian CSR frameworks carefully. Now let us discuss hidden exam traps. Students frequently confuse CSR applicability thresholds. Another common mistake is assuming all donations qualify as CSR. Students also confuse ongoing project treatment and unspent amount transfer requirements. These are highly important conceptual areas. Now let us discuss practical governance risks. Window dressing CSR projects. Related party implementation concerns. Weak impact assessment. improper project documentation, artificial expenditure classification, delayed transfers, defective disclosures. These create serious governance vulnerability. Now let us discuss due diligence perspectives. Investors increasingly evaluate CSR governance quality during acquisitions and investments. Poor CSR governance may indicate broader ethical weakness within management culture. Now let us discuss secretarial audit perspectives. CSR compliance forms important review area, especially for eligible companies. Committee constitution, disclosures, and spending compliance receive close scrutiny. Now let us discuss judicial and policy philosophy. Section 135 reflects stakeholder capitalism principles. The company is not viewed merely as profit maximizing machinery. It is viewed as a socially responsible economic institution. This is a profound governance shift. Now let us discuss technological transformation. Modern CSR governance increasingly involves impact analytics, ESG reporting platforms, sustainability tracking, and digital project monitoring. Transparency expectations are increasing rapidly. Now let us discuss practical drafting precautions. Draft clear CSR policies. Document project rationale carefully. Verify Schedule 7 eligibility. Monitor implementation agencies thoroughly. Maintain utilization evidence. Review unspent amount compliance timely. Ensure transparent disclosures. These precautions significantly reduce governance risk. Now let us discuss one of the deepest insights connected with Section 135. Corporate governance is no longer judged only by profits. Modern stakeholders increasingly evaluate ethical responsibility, environmental sensitivity, and social contribution. A company may be financially successful, yet governance reputation may still suffer if social responsibility appears superficial. Section 135 institutionalized this transformation in Indian company law. Now let us discuss investor psychology. Large institutional investors increasingly prefer companies demonstrating credible sustainability and social governance commitment. Thus, CSR governance now influences capital allocation decisions also. Now let us discuss broader national significance. Section 135 mobilized enormous corporate resources toward education, healthcare, rural development, sanitation, environmental sustainability, and disaster relief across India. Its economic and social impact extends far beyond compliance. Now let us discuss why this provision matters profoundly. Because it transforms corporate governance philosophy. It integrates profit with responsibility. It strengthens stakeholder capitalism. It promotes social accountability. It improves sustainability consciousness. It enhances corporate reputation. And it reminds companies that long-term legitimacy depends not only on generating wealth for shareholders, but also on contributing responsibly towards society, environment, and national development itself. For directors, Section 135 creates strategic social accountability. For company secretaries, it establishes sophisticated compliance governance. For auditors, it raises verification responsibilities. For investors, it provides ESG insight. For regulators, it creates structured social contribution mechanisms. For litigators, it opens evolving governance interpretation issues. For students of corporate law, it demonstrates how company law evolved from pure commercial regulation into a broader instrument of social governance and ethical capitalism. And for modern corporate India, Section 135 stands as one of the most revolutionary provisions, proving that corporate success cannot remain disconnected from societal responsibility, because sustainable governance ultimately requires companies not only to create profits but also to create positive impact, public trust, and long-term social value for the nation itself. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance, without consulting appropriate professionals and official sources.